YouTube, it's Tone. I'm back with another one for you. This one here is called the letter rogatory, and so I don't know if this is a factual letter that was actually sent out to the courts or not, but this basically what this does is breaks down the whole scheme that the courts do behind the scenes as far as securitizing criminal charges and where they send them and how they're monetizing the charges after they endorse them. So let's get into this briefly. Okay, so right here, state of Maryland and the district court for Montgomery County. And so the woman that, according to this document, the woman that wrote this is Christine Marie Chambers, letter rogatory for relief. So this is under the Hague Convention, Title 18, Clause 1781. So I, Christine M. Chambers, a living woman and executor for the Christine Marie Chambers Sestuke Trust. And the Sestuke Trust, basically that word just means a beneficiary trust, and she's noting herself here as the beneficiary, okay? So, which also entitles you to dividends from the securities that they're monetizing. So you technically should be entitled to some monetary benefits from this as well. So notice the core of my letter rogatory for the Montgomery County District Court and demand my name be cleared off this alleged criminal case for the following reasons set forth below. Number one, Christine M. Chambers has learned that this alleged court that has scheduled a case claim against me, and really what it is they're putting a claim against your estate, decedent estate. Okay, it's never about you personally, the physical human being. Since they are decedent entities, they can never make contact with the live living being that is you. So anytime you see a charge, anything against you, it's never against you. It's against your estate that they're placing the claim and lien against. Okay, so the court has scheduled a case claim against me. Is not really a court per the Constitution of the United States of America, meaning that it's not an Article 3 court, but rather a military tribunal under Admiralty jurisdiction and is operated as a private for-profit corporation listed on Duns and Bradstreet. Now that's actually a fact, because if you see in my community section of the channel, you're going to see that I posted the Duns numbers for all of the states, which all of the courts are going to fall under the jurisdiction of that. So since all of these states are essentially for-profit corporations, the courts that contract with them are the same exact thing. So I have learned that the fraud goes on behind the scenes of these alleged criminal cases, which are really civil claims in equity, and the steps taken to securitize these civil claims without giving full disclosure to the people. I am hereby letting the court know that I am opting out of any contract and do not allow any documents regarding me or my Sestuke Trust to be securitized and sold to any investors, etc. Okay, so as you may be fully aware, the fraudulent process is as follows. All cases are civil, though often fraudulently called criminal. The courts are operating under trust law, assuming the defendant is a decedent civil mortis, meaning a dead entity. After finding the alleged defendant guilty, the court clerks will sell the judgment to federal courts. Since the defendant is a decedent, presumed to be a ward of the court, incompetent, and unsound mind, the court officials call themselves as a so basically they're naming themselves as the beneficiary. They switch the roles on you to consider themselves the beneficiary as the powers that be, the international bankers, have concocted a reverse trust scheme on we the people who are supposed to be the beneficiaries because we are the actual creditors. So number 4, when a judge asks if a person understands, he is asking if a person is liable for the bond. I am not responsible for the bond of this case or these cases, but I will appoint the judge as trustee fiduciary to be the beneficiary and be the beneficiary of all the proceeds. The judgments are stamped with something to the effect, paid to the order of, on the back of, and taken to the federal discount window. The judgment now becomes a no. And so this is how they're getting that shit all done. So behind the scenes, what they're gonna do when you're not looking, they're going to go ahead and stamp it with the with the verbiage that I just mentioned here, paid to the order of, and they're gonna pay it to the order of either themselves or to the courts, right? And they all have TDA accounts, and they're sending all these securities directly to there. So, and then they're gonna use them to either purchase, savings bonds or things of that nature. So the notes are then pooled together and then become securities, which are yet pooled together and sold as bonds. Said bonds are liens against me, a defendant in error. The United States Attorney's Office has put a code number, NAICS, North American Identification Security Classification. Said NAICS numbers enable the United States Attorney Office to trade globally all securities. All U.S. federal courts are registered with the DoD, Department of Defense, where they are registered with the CCR, Contractor Central Registration, under the Department of Defense, which another department called DLIS, Defense Logistics Information Service, which issues a CAGE code, which means a commercial and a government entity, which everything corresponds with their bank account. So, number 10. Said United States Attorney's Office and courts have a DUNS number, and all of them do. They have EINs and all that, but they'll never give them to you, because then essentially what that would be is them admitting to being a for-profit corporation, right? Because real government entities are non-taxable because they're government entities. Now, as soon as the government start to engage in commerce, they are demoted from what would have been a government office to a mere corporation and a regular storefront, okay? So, number 12, all criminal cases not heard in an Article 3 court, District Court of the United States, are actually civil. However, the courts again commit fraud by labeling the case as criminal, even for an infraction as minimal as a parking ticket. Now, how can a parking ticket be a criminal offense when there's no victim? Okay, so that's obviously civil in nature. So all case and so this is why you want to be clear whenever you go into court to determine what the cause and nature of the actions are against you in order to determine if it's going to be commercial or criminal. Okay, so all criminal cases. All right, so what do we got here? So even for an infraction as minimal as a parking ticket, all cases which are pled out or have a guilty conviction label the civil defendants through unlawful conversion as felons when they are not. This is fraud upon the people at large, and certainly fraud upon the alleged defendants in error. The bank account is at a Federal Reserve of New York in New York City. The depository agreement is signed by the clerk of the court. And all of these people, they call themselves judges. They're all clerks of court. When you look at the paperwork that they're signing, whenever they sign for like judgments and things like that, they're signing right on the court clerk line because that's what they are. They're just basically administrators of the public trust, and they're pulling a fucking incredible fraud scheme on everybody, okay? So an escrow agent is used as a go-between between the clerk's office and the Federal Reserve Bank of New York. 16. The securities end up being listed through the 7th Court, Chicago, Illinois, then sent to the DTCC, the clearinghouse, whom lists the security for trading. 17. All of the lawyers involved are acting as a private debt collector according to the FDCPA, the Title 15, which I've mentioned numerous times, which all of them are third-party debt collectors. So Title 15 should definitely apply to all these people who are essentially third-party debt collectors and should be served with a cease and desist. The Bar Association exempts from having to be registered as such. However, they operate through call warrants, which are like a put or a call. Like stocks and bonds, right? So, and you got to pay a bond to get out, stocks and bondage, right? So doing margin calls is where they convert a case through similar of a writ of execution under the case number to buy equity securities, right? So they don't necessarily monetize them the way they're cashing out, but they can take the value of the case and use that to purchase securities through their TDA. So the Treasury Direct accounts, and these people are complicit in helping these people commit this fraud against the people. So this is the people at the TDA, the Treasury Direct accounts, okay, who are fucking literally committing fraud against all of you people. That shit is a straight crime. So 18, everything filed into court is securitized and turned into a negotiable instrument, and then turning them into securities. These items are sold as commercial items, calling them distressed debts, unifund. The items are then pooled together in what is now called a hedge fund, where they are sold globally. So you know, it's really not hard to see what these dickheads are doing to everybody, and operating with impunity because nobody has the wherewithal to realize what it is that's actually going on, and they won't tell you, but I'll tell you. So anytime where there is risk management involved, it is for the securities. There is an underwriting company. When the hedge funds are going into the global market, they go through Lure Herms, a bondholder and underwriting company and subdivision of Alliance SE of Munich, Germany, PIMCO bonds. Number 20. After 9 months, all paper is converted to a security status that is defined in Title 15, Clause 77A, B1, and are now considered to be an investment contract. The paper is endorsed to become a security, and then the trust is collapsed, right? And then they can cash out that way. So 21, the courts have an account with the IMF, International Monetary Fund, under Interpol. The judges involved, as the U.S. attorneys involved, do not have an accessible oath of office because they cover up the fact that the oath of office is between them and the IMF. Right, and so that's one thing that you always want to make sure that they have is you want to pull their bond and their oath of office to make sure that they even have standing to be sitting there hearing a case. Now, any of these judges that have a bar card are banned from sitting and hearing a case because that is a conflict of interest. Okay, so 22, the U.S. judge and U.S. attorneys are actually employees of the IMF and have expatriated out of the United States. That's why they're required to fill out a FARA, a foreign agent registration, okay? All of them are required to fill that out. So they are now unregistered foreign agents under Title 22, which states all foreign agents must be registered. These hypocrites don't even adhere to their own codes. Now, you wouldn't expect criminals to fucking follow the law, and so they're writing the law just for you. It ain't for them, okay? So 23, the court judgments are deposited with the IMF. Since this case obviously involves me, I have a drawing to all proceeds. See UCC 3-305 and 306, 306, which is the claims and recoupment and all that shit. Okay, so anybody who's been following me for any amount of time, you know what the UCC 3s are, okay? So tender of payment and things of that nature. So the court judgments are monopolized according to Title 16, which is a violation of antitrust law and also unfair trade practices. Okay, and so that's why Title 15 is going to apply with unfair debt collection practices. Okay, so indictments are true bills, meaning they are negotiable instruments. Okay, so and you could even get my book Magic Money, and if you were able to get your hands on the original charging instrument, which would be the indictment, you can go ahead and stamp that and hand it right back to them, and the case should be just closed right there, okay? Because they're going to take that and go cash in. So the district attorney failed to give me a 1099 OID showing me as the recipient of the funds, which is a fraud upon me. In my case, I have not been indicted but still request a 1099 OID unless the court wishes to close this account. 25. The unlawful funds through fraud and deception are deposited into the Federal Reserve Bank of New York, and they have not paid taxes on the income. Keep in mind, all of these are taxable events, which is why technically what I would do is fill out a 1099A and C on the case, and I would put the case number in the account section and go ahead and cancel the whole fucking thing. Okay, so according to the IRC, this is a Clause 7201 of Title 26 violation, willful failure to file with the intent to evade the tax. These are all taxable events. A copy of the depository resolution agreement was not made available to me from the clerk of the court. The clerk of the court makes deposits into Federal Reserve Banks of New York via electronic funds transfers, EFTs, using their TDAs and the TTL departments of their bank. These are all private actions that are taking place, and they're fucking evading taxes, okay? So you got tax fraud and all, breach of trust. You have so many things going on here, okay? So 27. The clerk has a PMIA, a private money investment account, which also has a government code. According to clerk's practice, the clerk of the U.S. District Court is the registrar in admiralty. Okay, and so that's going to be the fake judge. Okay, so 28, according to the IRS, Clause 6209, Decoding Manual, and the ADP, Automated Data Processing Manual, all 1099s are Class 5 gift and estate taxes, okay? And they are, because I've even filled out to get a return on the gift and estate side of the estate, of the gift and taxes, and I'm waiting on my return now. You know what I'm saying? And I haven't gotten anything back saying that it doesn't work. So these are all taxable gifts, which are liable for repayment to the original issuer, which would be you, because your name is on it. Okay. So I'm asking for a 1099 OID in this case. So the person asking for the 1099 is trying to get the 1099 OID, because that becomes a security which you can, at that point, once you have it in your hand, makes you the holder in due course, which makes you liable for repayment. So as I am not willing to give you to gift you the proceeds, I am hereby asking for the proceeds in their entirety, including the interest. 29. It is presumed that by the creation of the birth certificate, my body and labor therefore is pledged to the state. This is patently absurd, and this unilateral quasi-contract is lacking the full disclosure to their parents and their babies still in their cribs. I have never pledged my rights nor my body or any labor thereof nor any creation therefrom to any gifting program, including any court or court process. So, based on what I just read you, it's pretty clear to see what the hell's really going on here. And so we're going to dig into this a little bit further right now. So I am not a charitable organization. I demand all funds from the cases, current and past cases, be sent to me within 30 days, or I will file complaints to the IRS and Securities Exchange Commission explaining the fraud and theft committed upon me, and issue a 1099 OID. 31. I demand my name and my Securitizing trust name, Christine M. Chambers, in every variation of the name, be removed from any and all government databases indicating bad credit, which is a criminal charge and felony status. It's just basically a bad credit, and you know that because you know how after 7 years your criminal record becomes clean, just like 7 years of a bad credit report, it just falls off. So any criminal record essentially is them reporting a bad credit. And the commercial liens and or titles of criminal, felon, or debtor to be removed immediately and permanently, non-protunct. Non-protunct means from the beginning of time. 32. I hereby request a copy of the depository resolution agreement from the clerk of the court and a W-9 from the judge and the U.S. attorney involved if you wish to proceed with this case. Now what the W-9 is going to do, and this is where you have to start if you want to get their EINs, you got to send them a W-9, and this is going to put them in a position, and actually it fucking puts them up against the wall, because if they willingly don't give you their EIN, that's a crime, because they are a for-profit business and do have an obligation to give you that in order for you to file your taxes properly. Okay. So 33. I hereby notice the court that I am the executor of the Securitizing Trust of Christine Marie Chambers according to Title 26, Clause 303 and 7701. Companies, corporations, and associations and trusts are all decedents, which basically it's a ens legis, and it's a what is it? So the all capital names is basically a dead entity, essentially. So that would be referred to as a decedent. Okay. So this means that my all capital letter name is a legal estate. My all capital letter name falls into this class. I direct all of the affairs and financial affairs of Christine Marie Chambers and estate. 34. I demand that this case account be closed and no further steps be taken to securitize it. 35. I hereby ask the court as my fiduciary and trustee to notify local agents and agencies to put me on a do not disturb, do not detain list so that we do not have to go through this again. Additionally, I demand that my property, a 1997 Cadillac that was unlawfully seized under the color of law on July 13, 2018, by the order of Officer Stuart Jackson, badge number 7852, and currently being held for ransom and demand by the Kate McLaughlin, manager of the lot, which my property is being held for an exorbitant extortion fees at the Montgomery County Metropolitan lot for abandoned vehicles, be returned to my driveway located at 129 Summit Hall Road immediately. Additionally, I want compensation from the city of Gaithersburg in the amount of $10,000 for the commercial injury I have sustained from the loss of my property. Loss of time for working, the cost of certified mailings, notice and demand letters to the parties involved, the cost of filings and recording, as well as the expenses incurred for traveling as a result from being deprived the use of my private property, my automobile, which was unlawfully converted for public use. 36. I want to remain confident that the court and its officers want to follow the law and perhaps are unaware of the process of civil and criminal cases, and that public policy enforcers are ignorant of the aforementioned facts regarding their often erroneous administration of the Securitized Trust. 37. I expect no further harassment from rogue, unregistered foreign agents and public policy enforcers acting under the color of law. That's 18 U.S.C. So letter rogatory for relief, and then here at the bottom you have a space to get it notarized and all that. I would probably, if I was going to use this, set this up a little better here in the bottom. So basically, I just gave you a rundown of exactly what these clowns are doing and how they're securitizing all of your criminal cases and fraudulently calling them criminal cases when they're in fact civil in nature. And you know that due to the fact that these people are all operating in commerce and they have no standing in anything in any real criminal matters, due to the fact that they are corporations. So I think it's pretty obvious here, and I mean, if you dig into it even a little, you're gonna see exactly what it is that I'm talking about. And so also, you can go ahead and contact the Securities Exchange Commission as well if you want any further clarification on what it was that I just ran you through. And I mean, and so they're gonna go ahead and verify that as well. So just keep in mind, it is a game of chess. Stop playing checkers with these clowns until we